All right, let's jump right into this explainer and unpack the absolute whiplash of the Mazur versus CRS LLP legal saga. If you work anywhere near the UK legal sector, you've definitely felt the tremors from this one. I mean, it started as just a routine debt claim, and then completely exploded into a ruling that for a minute there turned thousands of hardworking paralegals and trainees into potential criminals overnight. So today, we're breaking down exactly what happened, and more importantly, we're going to map out the precise current position for paralegals, trainees, in-house legal teams, solicitors, and legal executives.
Here's our roadmap for today's explainer. First, the Mazur shockwave. Second, the 2026 appeal resolution. Third, the golden rule of responsibility. Fourth, the impact on legal roles. And finally, rules for effective supervision. Let's get to it.
Section 1. The Mazur shockwave, an existential threat to the industry.
So, to really grasp the current rules, we have to look back at the crisis that recently had law firm managers and trainees sweating bullets. It's honestly a fascinating look at how a simple statutory interpretation can completely upend an entire industry's standard operating procedure. Back in 2024, the law firm Charles Russell Speechlys used a debt recovery firm called GBS to recover some unpaid fees from a client. Now, the claim was issued by a head of commercial litigation at GBS, but here's the kicker. That person was actually an unauthorized person under the Legal Services Act. Imagine you're the client looking at the title on that claim. Would you challenge it? Well, they did. And by 2025, the case hit the High Court, setting off a massive chain reaction that ultimately forced a critical 2026 Court of Appeal intervention. When this 2025 High Court judgment by Mr. Justice Sheldon dropped, the entire industry literally held its breath. This judgment fundamentally threatened the daily operations of law centers, massive commercial firms, high street practices, you name it. It struck right at the heart of how law firms delegate work to unauthorized staff, creating a massive, crippling liability issue practically overnight.
Mr. Justice Sheldon drew a hard, terrifying line in the sand. He ruled that under the Legal Services Act 2007, unauthorized persons conducting litigation under supervision were straight up committing a criminal offense. He explicitly stated that sure, you could support a solicitor, but you absolutely could not conduct litigation under their supervision. Just like that, the standard industry practice of having paralegals and clerks issue routine claims on portals like Money Claims Online was illegal. The panic across the sector, it was immediate, and it was everywhere.
Section 2. The 2026 Appeal Resolution. The Court of Appeal Rescue.
But thankfully, the story doesn't end there. The industry rallied hard. Groups like SILEX, the Law Centers Network, and the Association of Personal Injury Lawyers pushed back aggressively, and enter Sir Colin Burrs and the Court of Appeal. They stepped in to sort out this massive regulatory fallout and basically provided a collective sigh of relief for the whole profession. The Court of Appeal recognized that the High Court's strict interpretation simply didn't match historical reality, nor did it fit the practical, day-to-day necessities of running a modern legal practice.
The Court of Appeal pulled off a brilliant legal distinction here to rescue the industry. They shifted the focus away from who is physically clicking the buttons on a keyboard to who actually holds the professional shield of responsibility. They ruled that unauthorized persons can lawfully perform tasks within the scope of litigation, provided the authorized individual firmly retains responsibility. This was a massive, much-needed pivot from absolute prohibition to structured, responsible delegation.
Section 3. The Golden Rule of Responsibility. Performance versus responsibility.
Okay, this right here is the framework that allows the legal sector to function today. The court fundamentally redefined what it means to carry on the conduct of litigation. They decided that an unauthorized person can absolutely perform the physical tasks, drafting documents, filing them, pinging emails to the court, as long as the authorized individual retains full direction, control, and responsibility. You've got to clearly separate the physical performance of the task from the actual legal conduct of the litigation.
Sir Colin Burrs basically boiled his core thesis down to this. The authorized person, whether that's the solicitor or the chartered legal executive with practice rights, is the one conducting the litigation in the eyes of the law. It's not the paralegal or the trainee doing the groundwork. And because the unauthorized person isn't officially carrying on the conduct of litigation, they aren't committing a criminal offense by doing the delegated work.
It's really instructive to see how this played out in the courtroom. Initially, the Law Society argued for a super strict interpretation, suggesting that a solicitor must approve every single document before it's issued. The Court of Appeal rightly pointed out that if that were true, thousands of solicitors across the country would literally be committing criminal offenses daily just by running standard, high-volume claims departments.
So, thankfully, the court ruled that while complex, novel situations definitely require tight control and strict prior approval, proportionate, routine supervision, like regular catch-ups and file sampling, is perfectly acceptable for simpler, run-of-the-mill claims.
Section 4. Impact on legal roles. Where do you stand? All right, so how does this golden rule actually hit your desk on a Monday morning? Based on the new SILEX and SRA guidance, the lines are super clear now. For paralegals and trainees, you remain unauthorized. That means you can do the physical work, sure, but your name cannot be on the file as a responsible party. You must be explicitly supervised. For in-house legal teams, you can comfortably advise your organization internally, but to formally conduct litigation or act as an advocate in court, you still need specific authorization or independent practice rights. Solicitors, naturally, remain fully authorized to conduct litigation independently and to delegate those tasks, keeping all the legal and ethical responsibilities squarely on their own shoulders.
Now, if you're a CILX member, this case was deeply, deeply important. A chartered legal executive without practice rights is still, technically speaking, an unauthorized person for litigation purposes. So, while the ruling confirms you can lawfully work and perform tasks under the supervision of an authorized person, acquiring independent practice rights is still the absolute essential step if you want to conduct litigation in your own right without a supervisor looking over your shoulder, and to be able to delegate tasks to others yourself.
Section 5. Rules for effective supervision. Staying compliant.
Because delegation is completely legal again, regulators are demanding receipts. The courts saved the industry's working model, but the regulators expect you to actually prove you're supervising your staff. The SRA has made it crystal clear, supervision cannot just be passive. You can't just slap your name on a paralegal's file and then never look at it again. Supervision has to be a highly auditable, meticulously documented process managed by experienced personnel. If a regulator walks into your firm tomorrow, you need a rock-solid paper trail proving the supervisor is genuinely directing and controlling the litigation.
To maintain compliance and protect consumers, you've got to actively bake these steps into your firm's management system. The SRA guidance specifically highlights the need for face-to-face supervision at least once a month, and very importantly, the random sampling of live files. Actually, the SRA shared a pretty revealing example of a firm that had to hire 3 full-time qualified lawyers just to properly direct and sample the work of their paralegal claims team after a regulatory investigation. So yeah, you absolutely must build these active guardrails into your practice.
And it is vital to remember this absolute red line. Trainees, paralegals, and CLEs without practice rights must never, ever cross the line into independently determining legal strategy, making substantive decisions about the proceedings, or dealing with the court or other parties as if they're the responsible party. Think of it like a pilot and a co-pilot, right? The unauthorized staff can help fly the plane, they can manage the instruments and follow the flight plan, but they cannot independently decide the destination or take legal responsibility for the flight. The authorized supervisor has got to be the one holding the reins at all times.
We've just seen how a single signature on a routine debt claim almost brought down the standard operating procedure of the entire legal sector. So, given the incredibly serious regulatory consequences of getting this wrong, and the clear mandate from both the Court of Appeal and the SRA, I want to leave you with this final, critical question to take back to your practice today. Is your firm's supervision actually auditable, or are you just assuming you're covered?